Welcome, Health Law Section members. Today we have a very special guest who is our member spotlight for the month of May. Roger Handberg is recognized for his prosecutorial precision and strategic command of high stakes litigation. He's earned a national reputation for successfully managing major financial crime, public corruption, and regulatory enforcement cases. His Department of Justice insights and courtroom credibility make him a powerful ally to clients facing parallel civil, criminal, and reputational risks. So you can imagine how honored I am to be able to have the opportunity to interview him today and spotlight him as one of our Health Law Section members. Roger, welcome.
Well, thank you very much for having me, Rupa. I'm looking forward to this.
I'm looking forward to it as well. So, first, go ahead and take a moment and introduce yourself.
Well, I'm probably a pretty good example of kind of the way that your career can end up in a place different than where you started. So I'm born and raised in Orlando. My father taught at the University of Central Florida. He just retired after 54 years of teaching political science. So I always knew I wanted to be a lawyer. So I went to the University of North Carolina. I went to Harvard Law School, and I wanted to do general commercial litigation at a large law firm, and that's what I started doing. And I had a fantastic time doing that. I was at a great law firm in Atlanta. But when I was there, I had a number of friends who were going to the United States Attorney's Office, and that really got me interested in public service. And so that's where I decided to take my career. I started first at the Florida Attorney General's office doing civil enforcement, False Claims Act, civil RICO, unfair deceptive trade practices. And more than 22 years ago, I had a chance to come back home and be a federal prosecutor in my hometown of Orlando.
Incredible. It sounds like quite the journey that you've had.
Yeah, I mean, if you had told me in law school that I would be doing a criminal prosecution, I would have told you you were crazy. I took one criminal law class in law school. I took the basic class, but I really had a great time. I mean, what I wanted to do was to use my law degree to help people, and there was no greater privilege that I had than representing the people of the state of Florida when I worked for the Florida Attorney General's office, and then representing the people of the United States and doing the work of the people of the United States in federal court in the Middle District of Florida. And one of the things I enjoyed about my practice at the U.S. Attorney's Office, because you get experience unlike I think any other sort of experience. You get to be in federal court, you get to manage your own caseload, and I had a chance to do the cases that I really enjoyed, which were victim cases, usually on the financial and public corruption side of things.
So, what would you say was your career defining moment?
For me, it was probably a case that I had early in my career because it was a case that I learned a lot from. And it was a person by the name of Lou Pearlman, who you may not have heard of Lou Pearlman, but you've heard of him in the sense that he created the Backstreet Boys in NSYNC. But what he was also doing for more than 20 years was running one of the largest Ponzi schemes in the history of the Middle District of Florida. And why that was such a defining moment for me was I had not been with the office for very long, but the office trusted me with that case and gave me the opportunity to do a really significant case where I really got to see firsthand, the good that can come from doing victim work and helping people who were in those terrible situations. So I learned a lot from that case, and the lessons I learned from that case are something I carried forward and carry with me today.
What would you say is kind of the intersection of what you do in health law?
So one of the things I really enjoy about health law is it's one of those areas that impact every single one of us. And so it's the type of law where no matter what your interest is, you can find something where you can be of help. And so what I've enjoyed doing is working with clients directly because health law can be very complicated. And we are a country where we're a system of law and rule of law is how we operate. Sometimes people need lawyers to be able to help them navigate those. And so what I like about health law is a lot of what I do in some of my day-to-day work is I help people once there's a problem. In health law, you can be proactive, and a lot of times you can help people prevent problems from happening in the first place and help them with compliance. So the compliance work that I get to do, working hand in hand with clients, I really enjoy that aspect of my practice.
So for one of the things we like to do with our spotlights is also give our section members a chance to kind of know you on your personal side. So what are some of the things you do outside of work that keep you busy?
So one of the things my wife and I started doing a number of years ago, we wanted to take advantage of what Florida has to offer. And so we really got into kayaking of all things. And we love to go kayaking. And there's a lot of really wonderful rivers. You can kayak in the ocean. And it's a real nice chance to be outside, to enjoy the sun, to enjoy the water and just to get away from it. And I think it's important for anyone in the law to have some outside activity they do where they're not in the four corners of a courtroom or they're not within the four corners of an office and they can get out. And I think there's no better way to do it than being in nature. So we've really gotten into that.
I think that's a good plug too for just Florida. Why practice in Florida, right? You can have a lot more opportunities to do things like that year round and have that kind of work life balance as well.
Yeah,
Yeah.
it's one of the reasons why I've always been proud to be from Florida and really happy to have had the chance to come back. When I started my career, I didn't really know where I was going to end up, where my career was going to take me. I just got newly married, and my wife had a career, I had a career, and we're just very fortunate to have the chance to spend most of it back in my home state.
So now, having had that journey and very successful career, what's some key advice that you would give junior attorneys just starting out in the practice of health law?
So some of them are things that I've just seen over the course of my career. One is ask questions and do that early and do that often. And I can say that as someone who has been the person asking questions, but also the person to whom questions have been asked, especially when I was in supervision. Being a lawyer, you're part of a profession. And you're part of a profession where people have come before you, and someone has helped every single person who's a successful lawyer. And successful lawyers are looking for people to kind of pay that back to. So take advantage of it, and ask those questions and to show your interest. The other thing I would tell people is the complaints that I've heard over time about lawyers. I would say more than 90% of them fall into one bucket, and that's lawyers not being responsive. And we would have this issue sometimes with prosecutors. I would see it when I worked at a firm. And you know what? I would tell people, about those situations is most of the time your client is going to understand if you have to give them advice, which is maybe not the advice they want to hear. But what they won't understand, and what I don't think can be defended, is not returning phone calls, not emailing your client, not keeping your client up to date. And I can tell just from my 31 years of practicing law that there's some people who are not good at that. And so I tell younger lawyers, get into good habits. And if you get into good habits earlier in your career, you will follow those habits. So, what I try to do at the end of each day, I have a rule where I try to respond to an email, for instance, that I get that day. And if I get one in the afternoon, I'll try to respond before noon the next day. I'm not going to tell you that I've done it every single time, but find good habits of communication and responsiveness. And I think that you'll find that you'll be appreciated for doing that, and your clients will appreciate it very much as well.
Absolutely. That both of those are such critical pieces of advice. And I think the communication, sometimes it's easy because it's our life and it's what we do, right? It's our day to day. But for the client, they come to us, it's probably something a little scary for them. And so just hearing from us can make all the difference, even if we don't have a finished product or an answer for them, just having that touch base is so important. And then also what you said about I think junior attorneys sometimes see their senior attorneys are so busy and they're afraid to ask questions, but it's so important. And I know you're such a great mentor, and I know I never mind if a younger attorney comes to me and indicates they need help, that's going to be my priority over. It doesn't matter what's on my plate. I'd much rather do that on the front end than fixing something, after the fact as well.
Yeah, and we all remember that we had someone who did that for us.
Yeah,
And
absolutely.
like I said, it's a profession. I mean, we're about developing those who are going to be coming behind us to continue with the ideals and the sort of the way that things should be done. And hopefully we'll never lose that as a profession.
Yeah, I don't think we will. And I think the work that we do as a section is important for that purpose too, giving people, if maybe not someone within their workplace, but at least they can build colleagues and peers across the bar through activities and participating in things like the section. So
I think this section performs such an important role because, part of professionalism is being connected to other people in the legal community. And what I've always found, and I'm an introvert by nature, I had to kind of force myself to put myself out there. But when I did, I realized just I got so much out of it, out of those relationships, and it makes for such a more cordial practice. And then what you also find is that a lot of times we're all in this together. We're all just trying to do the best we can, and especially in health law, where I mean, sometimes the situations are unbelievably complicated. You're trying to untie regulations from federal statutes to state statutes, and the intersection of those things can be daunting. And to have someone who's knowledgeable and is cordial and is willing to lend a helping hand, like we have in this section, I think goes a long way to promoting just good lawyering by everyone in the section.
we're definitely very fortunate in that regard.
Absolutely.
So, as far as health law goes, what do you see in your practice as something that's emerging, in healthcare law that maybe our section should be focusing on or bringing attention to?
Well, and I think the section always does a fantastic job. And the issue I'm going to talk about is one that's been kind of hanging out there for a little bit, related to the False Claims Act and the constitutionality of the key TAM provisions. So the Justice Department earlier this year did an announcement about how much had been recovered from key TAM actions. And if you look in that data, and in particular the data from cases involving the Department of Health and Human Services, which are going to be healthcare fraud related cases. The recoveries that the government got on cases they intervened in was large. I think it was maybe the fifth or sixth largest they've ever had. The recoveries for cases in which the government didn't intervene, so that's where a relator and their counsel took the case forward, were the largest they've ever been in history. And they were double the next largest year. And I mention that because a lot of the enforcement work that's being done out there in the healthcare space on the key TAM side is being done by relators and relator counsels. And we've got this issue up on appeal with the 11th Circuit about whether that is constitutional or not. And if it's found not to be constitutional, and it will probably get reviewed further. I'm not an expert on any of this stuff. That's just what, the experts say. But I think that's going to dictate, I think, a lot of the enforcement actions. Is the government going to be going its own way and having to do all of that itself? Or are they going to continue to have relators and relator counsels who are doing it? And I think that's going to be a big impact, at least on the enforcement side, once that decision comes out.
Yeah, when I started practicing 25 years ago, that was like unheard of, right? I can't even remember at what point, but at some point the plaintiffs' attorneys, there was a real uptick, right? Plaintiffs' attorneys, key TAM actions, relators, there's a nice little percentage they could get, a nice little percentage their attorneys could get if they won, a significant sum of money. But pretty much if the government didn't intervene, it was dead in the water, right? That used to be the norm. And I noticed what you mentioned. Now it seems like they have the funds to bring it, even if the government doesn't intervene, which then does become it does raise constitutionality questions because you basically have private people enforcing a government, a federal regulation.
Yeah, and that's the issue that's with the 11th Circuit. And all eyes will be, on the court to see how see how it comes down in that particular case. But yeah, we've seen in health law, I mean, we've seen, I think, some of the benefits of some of the technology that's available. Some of the cases that maybe would have been hard for someone to potentially bring, a while ago because you wouldn't have the resources to be able to do it. A lot of times, there's scalability and folks can take those cases on in ways that maybe they couldn't in the past. And I think there's also been a lot of success on the enforcement side. And so I think there's been good templates that people can follow in terms of things that might lead to potentially successful recoveries. So, the nature of some of those enforcement actions, sometimes the type of cases change over time. But it's been pretty reliable for a long time that every year, usually the largest part of the enforcement recoveries on the False Claims Act are in healthcare fraud related cases.
Yeah. Makes it a little scary for practices we represent, especially when, I mean, obviously if you're engaging in something fraudulent, that's not right and that should be brought attention, but sometimes there is no validity to it, and that's really hard on our healthcare organization. And there's a big cost to our healthcare organizations when it's just a disgruntled employee and who really doesn't have anything but is hoping for some kind of big payday. And it is it I think it's important, and it's good that we have attorneys like you involved who kind of follow and track what's happening and are cognizant of it to keep our clients informed, because it's just like anything else where you have a litigious plaintiff's bar. We don't want healthcare and key TAM actions and relator actions to become like the reputation that ambulance chasers have, for as a profession. It should be about bringing forward when there is true fraud and not about kind of bringing down to their knees legitimate practices that have to then expend significant resources to kind of prove that there was no validity to it. And I think that's where it would be beneficial to kind of keep it something that requires government involvement to come forward. Would you agree with that, or do you kind of think that the trend is fair?
I think there's a balance, as with anything. I certainly, have seen cases that don't have merit. And when I worked at the U.S. Attorney's Office, and the office I was at and led for a number of years is the second largest in the country by population. And because of that, we often had one of the largest key TAM dockets because we serve more than 13 million people. We're in Florida. So we saw a lot of those. And part of the job of the United States Attorney's Office was finding those cases that had no merit and dismissing them or bringing them to a conclusion sometimes or allowing the relator to continue with the case on their own as the decision might be. Because the reality is, and that's one thing, about working at the U.S. Attorney's Office, there's, one of the quotes, and I always remember this, it was framed and it was up in our break room for many years. There's a case called Berger versus United States, which is a 1935 case. And anyone who works at the Department of Justice is familiar with the quotation from that case, but it talks about the role of the United States Attorney. And I won't try to quote it all for you here today, but I can paraphrase it. And what it talks about is your job isn't to win. It's to seek to do justice. And I think that's always got to be an important part in terms of how any of these False Claims Act cases are viewed is the concept is to do justice. And sometimes we see some that are as you mentioned, from a disgruntled employee who maybe doesn't understand the situation. Sometimes it's a result of data mining. I mean, sometimes, it looks like there's an outlier out there, but there's a perfectly fine explanation. And so one of the things I enjoyed.
Statistics can lie.
Well,
That's-
and
yeah.
I often would say, maybe they're the beginning of what would cause you to look at something, but you have to look at it with an open mind because there could be another side of the story. And I guess I've seen that other side of the story play out enough to know that, judgment should be held until the investigation is completed. And one of the things I enjoy doing is getting a chance to use what I know and from my time in the government to help people navigate those situations so we can get to the truth and justice
Mhm.
of a situation.
Yeah. I mean, I think the way you explain it, it kind of helps me to understand why it makes me uncomfortable. You do have the Department of Justice, they've made a decision it didn't have merit, and so when they've made a decision based on the facts that there's no merit, to then say, okay, relator, you can still bring this forward, it just kind of feels like, well, why should they be able to do that? But then you see the cases where it is brought and it is shown to have merit. So it's kind of like, there is probably somewhere where there's a balance that can be struck there.
Yeah, and as you can tell, I successfully did not actually answer the question that you asked, and hopefully that's okay. Because I have seen it both ways. I mean, I have seen things that on their face you would think would never actually pan out to being something, and they do. And then I've seen other things where you think from the beginning that there's something there, and
It's
it's
not.
there. And that's why I think it's important for for these cases to be investigated, and for the truth to be discovered and then the decisions to be made. But it's scary. It's scary for a client to have to go through that because the penalties are so large. And you were talking about financial incentives, and that's the financial incentive. Treble damages, attorney's fees, share for the relator. There's these financial incentives that are built into it to create that, and it's worked. As you can tell from the numbers I talked about before, there's a large number of these cases that are being brought and pursued, and obviously successfully as well. I mean, that's the other thing about those numbers is
Right.
there's
Yeah.
cases.
I think where some type of, like you said, it's before the court right now, some type of guardrails would be good, is so often you never get to that point of proving merit, right? Because it's so costly for, whether it's physician practices or hospital systems, whoever is facing this relator claiming there was some type of fraud, it's just too expensive to prove it, right? And so, and it's not a government investigation anymore. It's a relator bringing the thing, and so you end up settling. It's not necessarily was based on the merits. It's just to help defray costs that it would take to prove that there was no merits.
Yeah, and it involves concepts of litigation risk. And when as part of the litigation risk, you've got a statute that provides for a multiplier. It maybe puts you in a different analysis than maybe you would be
Right.
if it didn't have that. So I can certainly appreciate that point, and I'm looking forward to seeing what the 11th Circuit says because this issue has been one that's been percolating out there for a little bit, and I think we're all looking for some guidance from the court on it.
Well, thank you, Roger. This has been wonderful. I really appreciate all the insights and also your membership with our section and your service to our section. It's greatly appreciated.
Well, thank you so much for having me. I really enjoyed it, and I appreciate getting a chance to be a member and looking forward to meeting hopefully more members soon.
Sounds great. Thank you, Roger.
Thank you.